Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Sarah Boone's motions, as well as some responses from the judge and some other uploads, have hit the Orange County court clerk's website. So we're going to go through her motions, and we might stop there because it's like 29 handwritten pages. And as we've learned, Sarah Boone, some of her handwriting can be really neat and some of it can be hard to decipher. So let's jump right into Sarah Boone's motions. All right. So this is her motions. They were actually scanned into the court website yesterday, which was July 30th. And as you can see, 29 pages. So I'm going to kind of sift through parts of this. As always, if you want to view and read these for yourself, you can jump over to the Orange County clerk's website into the records. So here we go. In the Circuit Court of the 9th Judicial Circuit in Fort Orange County, Florida. State of Florida versus Sarah Boone. Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. Comes now Sarah Boone, pro se, indigent defendant. I like how she adds the indigent there. Respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural preparation with professional guidance during her forfeited right to counsel by the court as pro se attorney and her proposed lawful representation of self in her criminal case. Defendant's justifiable reasons for requested relief and assistance are as follows. Now, I don't know if she realizes this, and it seems like these were written and mailed before she spoke with the judge last week on Friday, but the standby counsel is not going to be like her lawyer. It's just they're going to be standby, which means they're going to assist her, but she forfeited her right to counsel. So it's not the same. So if she thinks it's the same, she's going to be clearly disappointed when the judge tells her this. 1. The defendant's sixth constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. No. We all know that she's the one that forfeited it. Judge Kranick clearly explained to her that she forfeited her right to appoint a counsel due to her behavior. By the defendant's lawful practice of her entitled first constitutional right to free speech and her God-given right to do so, by writing her experience, derived truth, and providing red flag exposure in her correspondence to the court, requesting needed intervention to avoid present circumstances, she has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted while having the ability to be level equally with the prosecution. And she did that to herself. So she's a smart person. We've learned that from her letters. Sarah Boone is not stupid. And I would never say she's stupid. She just does not want to take responsibility, and she wants everything to go her way. Period. 2. The defendant is not an officer of this court or any court or legal system as a whole. Yeah, I think that's pretty well known, and nobody will argue with that. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking requisite professional competency, experience, expertise in the field of law, presently and historically. The defendant is defective and ineffective counsel to self as a result. Wow, that's like the first negative things she said about herself, which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. I feel like she's finally seeing the problem with not having the attorney, but she's of course not going to take the blame. That's the problem. So, Sarah, you are writing all this stuff that I'm reading here, and it's all correct. The fact that, you're disadvantaged by not having this regular attorney. But, again, you did that to yourself. 3, the defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities into her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. By the court rejecting professional, educated, experienced aid and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include: A. The defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. Again, we have to remember this was written before she saw the judge last Friday. With only 4 days to submit my demands and motions delegated by the court on or before 7/22/24. B. The defendant has not reviewed from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. Again, this is resolved with everything that we spoke about last Friday. She goes on to say with 4 days. C. The defendant does not have access to a computer. Judge Cranick is making that possible as of August 5th, so that problem goes out the window. D. The defendant does not have access to the internet. That part we can't speak to, but I'm sure he'll address that. E. The defendant has extremely limited, irregular access to basic tablets supplied by OCCD. Again, she's going to have access to a laptop for 8 hours a day. F. Defendant has access to payphones for collect calls only, limited to 15 minutes each call. They may work with her on the call situation, because obviously she does need to make calls to take care of, whatever she needs to take care of for a case. So I'm sure that something can be worked out with the judge as far as that issue is concerned. G. Defendant does not have access to organizational supplies or production equipment, copier, printer, etc. I don't think she's going to need that, but they'll probably give her pads of paper and pens. H. Defendant does not have access to a meeting place for privacy and case review preparation. Again, the laptop is going to be provided to her, and I believe they're going to give her somewhere to work on her case. I. Additionally, daily obstructions and hardships, disadvantages, difficulties will likely come about due to being incarcerated, and once my case materials are finally received. Continued application and reasoning and further lawful support of defendant's request for immediate relief with standby counsel to aid and assist in preparation of her criminal case. Her issue is she's not understanding what a standby counsel is going to do and not going to do, I see. But we do have a court date coming up, I believe next week, so the judge is going to go through all this stuff. So at the end, we'll bring that up, and we'll look at the clerk's website again. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Well, she's going to have a public trial because that's what she wants. Speedy, well, that's sort of been on her end. By an impartial jury of state and district wherein all crimes shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And then she's quoting Amendment 6 of the United States Constitution, which she pretty much threw that one out the window. But she's having a right to her trial. She's being provided with everything that she needs per the court. B, right to counsel is assured by the 6th Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment, as well as state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney. So it seems like she's repeating this stuff here and then just quoting stuff. So let's see. C is waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused. No, you haven't. But you've given them a hard time, whereas they can't work with you due to, they just can't work with you, Sarah. You insult them, and just it's very documented. Judge Cranick was very kind, and it's over 4 years. He just wasn't going to do it anymore. It's made by a person with full capacity, unprepared, that is knowingly, voluntarily forced, and clearly and unequivocally rejects representation or assistance by an attorney at law during the pending proceedings. Yeah, she's quoting law dictionaries and such. Defendant's decision to waive their right to counsel must not only be competent, but also knowing and voluntary. I think she's very competent. But as far as she's not a lawyer, well, yeah, we all know that. But she's very competent. And again, I think she's pretty smart in a lot of ways, and these letters have proved that. The right to waive counsel forced by the court is the right knowingly to proceed in ignorance is sufficient for purposes of both the state and federal constitutions, that the record taken in its entirety show the defendant comprehends that a waiver of counsel means that they will proceed into the labyrinth of the law without the assistance of an attained guide. It's a fact. You're jumping in there without a lawyer, which you had 8 of them. The court must first make inquiry into his competence and be reasonably satisfied it before accepting the accused waiver of counsel. She never gave. Well, you kind of did. He didn't ask you because you took advantage and he forced it on you. So, yeah. And as far as competence, again, I believe you are completely competent, Sarah. I believe you completely are, and I'm sure the judge has taken that into account very early on. Okay, I'm going to skip through this because she's just kind of going through. The trial was a farce or mockery of justice or was shocking of the consequence of reviewing the court. Purported representation was only perfunctory, in bad faith, a sham, a pretense, or without adequate opportunity for conference and preparation. So it looks like she's quoting some court cases here and going on about ineffective counsel, which honestly, that's not true. But let me read this because it looks like she's saying some comments in here. Ineffective counsel is both a standard of adequate performance for a lawyer in a criminal representation and a failure of due process of law to the criminal defendant. A person who has suffered a punishment in a criminal proceeding, and she writes, I was repeatedly lied about by former attorneys to the judge who is unjustly believing all over me, falsely accusing me of an inappropriate and wrong strategy of removing attorneys who withdraw from my request to the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel. I completely disagree. 8 people can't be wrong, Sarah. Maybe 7. I think there may have been one that was sort of working with you, and then they had to leave. I believe there was something to do with that one. But all these attorneys, they're not lying. It's again, you got to look in the mirror because you don't want to take any responsibility for your actions, not only on what you did to George, but you don't want to take responsibility for the fact that these last 4 years you've pretty much screwed yourself as far as the right to representation as an indigent defendant. And she's going on to say, due to ineffective assistance of counsel, the federal courts in 1999 set this record sentencing aside. So again, she's going through law books, what have you, at the library at the jail, which is good because she needs to learn a lot. Florida Constitution, 2024 edition, Article 1, Declaration of Rights. So here she's just going to copy stuff from that book, so I won't go through it. If you want to read it, go on to the website and download this. It looks like it's all just copies. Because this is 29 pages, so we kind of got to push through part of her stuff that she's just doing a lot of copy and what have you. Again, it's all mostly just her going on saying how she was a lawyer was taken away from her unjustly, how she's so wronged, and we all know that that's not the case with Sarah Boone. And this goes on for quite a while, so yeah, I didn't go through all this. I just sifted through this, so when it all came up, and because a lot of documents dropped yesterday on the records, the Florida Clerk's records site. She's still copying, which is good because we're getting through all these pages here. A lot of, remember when you were in school where you used to copy like the encyclopedias and books from the library so you can go home and reword it? She was sitting there copying stuff in the library at the jail, obviously, here. More quoting cases. Let's see, thus a fair trial is one in which the evidence subject to, and it's going to be a fair trial. I completely believe that Judge Korenik is doing everything in his power to make that so. Again, the defendant herself is causing all of these problems. Let's see, appointment procedure, federal law and local court rules govern the procedure for implementing the right to counsel. Then she goes on to, looks like she's copying up notes of adversary counsel. And this is just one of her motions. All right, let's see. Defendant is requesting collaboration, correct understanding, and overall perspective of in her extraordinary circumstances by rendering her cognitive incapacities, procedural abilities, and extremely limited capabilities altogether as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by court. Bottom line, she wants a standby lawyer, which is what she's writing here, and I believe she's going to get one, but Judge Korenik is going to explain to her what he or she is and is not going to be doing for her. So again, this was mailed, it looks like completed the mail on July 18th, and it got scanned into the website yesterday. So let's jump to the next one. Just since we're back here, there is a hearing on the 5th, so on Monday. So I'm assuming he's going to go over all these motions that she mailed in and let her know what he's going to approve, not approve, etc. All right, so here's another one. So here is a motion she wrote. Temporary motion for reservation of proposed costs to acquire an investigator for the defendant's defense and trial. She has one, which was Mr. Lane. I'm assuming he's going to be really thrilled to be working with her. Comes now Sarah Boone, pro se. All right, investigator to be announced. I believe it's Lane. How to calculate. She puts unknown by defendant. Reason no discovery or case materials provided to defendant from the judge. And she's going on about how she can't meet that date, which we know that already. I believe he's going to approve probably some of this, because obviously she needs the investigator to work with her, and she's got Mr. Lane, so I don't believe that this is going to be a motion that's going to be denied. To what extent he's going to approve, I don't know. And I'm going to sift through here, because this one's another 20 pages. Because Sarah sure likes to write. Again, I think she may one day write a book. Let's see. Conclusion. This temporary motion for reservation of proposed cost to acquire investigator for defendant's defense and trial should be granted. I think she's going to be granted this for sure. All right, let's see if we can move on. Certificate of Service. I hereby certify that an original of this document has been filed by U.S. mail with the Clerk of Court of the Ninth Judicial Circuit on this 18th day before the delegated due date by the Court of July 22nd, 2024. I further certify that a copy of this original document can be e-served via Florida Court's e-filing system to all attorneys and other parties on record. And let's see, so that was mailed. This is still continuing the motion for the costs. And she's going on about how the defendant is trying to avoid any further persecution and penalization from the judge in court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The extended time limit of waiting to receive the defendant's discovery and case materials provided by the court has forced the submittal of this temporary motion. I think he's going to extend her ability to do all this research, because she's not going to have any of this stuff until the 5th when he goes through all these motions next week. They give her that, they give her access to that laptop. So I do believe she's going to get some more time. I don't know what he's going to give her, but we're probably going to hear that she gets at least another month, maybe 2. So if she's set right now for October, maybe December. So we'll see. We all want to get this on the road. So, but at the same time, Judge Cranick is going to make sure that she has enough time to go through her discovery and not make that an area where she can do an appeal later on. So this looks like it's all still the same stuff, though. Let's see. All right, now we move to another motion. Temporary motion for reservation of proposed cost to acquire all witnesses for defendant's defense and trial. Let's see. Witnesses to be decided. Total amount requested. Again, she's stating that she doesn't know about the cost, which she wouldn't, because that's normally what an attorney would do and take care of that with the court. Temporary motions being submitted. She submitted it on the 22nd. Let's see. Defendant is trying to avoid further persecution. See, she's repeating a lot of the same stuff here. So let's see. Let's get to... So she looks like she's saying a temporary motion for reservation of any and all costs proposed to be incurred to acquire all witnesses needed for the defendant's defense and trial of her criminal case should be granted. I believe there's probably a lot of those already done. So I don't know how much more needs to be done in that case. I'm sure more will come out with the discovery and and they'll know from there. But with all those attorneys, they would get to almost a pre-trial, and then Sarah would write one of her infamous letters and, oh, we can't work together anymore. Or she would, offend them in some awful way. Okay, here's another motion here. Temporary motion for depositions to be conducted. Again, I think that probably all the depositions are done, but that's, obviously something she's got a right to, from what I understand. And again, I'm not a lawyer. I don't play one on TV or even on YouTube. But, let's see. Again, she doesn't know costs, and she doesn't know a lot about that, which is why she needed an attorney. She requests to take depositions for her defense, and no discovery or case materials have been provided. Very, very repetitive, Sarah Boone. Okay, let's see. All right. We should be getting to the next one here. Okay, there's the envelope. Okay, so those are those motions. Let's see. I think we may have them. Some of them were actually typed out from what I last saw. Let's take a look. All right. All right. This is the a response, the Justice Administrative Commission's response to motions seeking due process costs. So this is a response for one of her motions, it looks like. Comes now the Justice Administration Commission, which is the JAC, which we've heard about a lot during her case. By and through the undersigned attorney files this response to the above cited motions as follows. 1. The defendant is seeking authorization for various due process costs as follows. Appointment of standby counsel to assist the defendant, cost to take depositions, an unspecified amount for a defense investigator, unspecified expert witness to assist the defense witnesses, cost for unspecified witnesses to appear at trial. Again, most of this is probably going to get approved, I think, beyond what's already been done. And then standby counsel be explained to her about what is allowed and not allowed. Not that she won't try to push the limits on that. 2. As an initial concern, any future requests for due process costs, such as requests for transcripts, investigative costs, or experts, need to be served on JAC prior to the court considering the matter. The defendant is responsible for providing JAC with any motions for due process costs so that JAC can respond accordingly to those requests. 3. JAC may only pay for due process costs pursuant to sections 29.007, 27.40, and 27.53042 Florida statutes. 4. As directed by section 27.425 Florida statutes and the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract, policies, and procedures. JAC objects to any compensation rate in excess of established rates, and that is in bold. Standby counsel. 5. As for the appointment of standby counsel, the court entered an order on June 28, 2024, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on the issue of appointed counsel. Deposition-related costs. 6. As for costs to take deposition, the defendant is authorized to incur costs to take depositions for those deposition authorized under the Florida Rules of Criminal Procedures. The notice of taking deposition substitutes for a court order for purposes of the court reporter seeking compensation for appearance fees. 7. As for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serving county law enforcement. 8. As for transcripts, JAC has no objection to regular paid rates. The motion and order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, date and type of hearing, and recording type and date of recording. The defendant should only order those transcripts necessary for defense of the case. 9. The uniform statewide rates are set forth in the General Appropriations Act. Court reporting services cannot exceed these rates. Private investigator costs. 10. Pursuant to the uniform statewide rates, the rates for investigators cannot exceed $50 per hour. 11. As required by Florida law, any private investigator providing services in Florida must have a Class C license from the Department of Agriculture and Consumer Services and be employed by an investigation agency with a Class A license. 12. If the court grants the motion, the order needs to indicate the amount authorized for the defense investigator. Based on the docket, it appears Prison Break Investigations, Billy Lane, which we previously saw in court with her last week, may have already been appointed to this matter. JAC does not object to the court authorizing $5,000 for a defense investigator and $500 for the investigator to obtain case-related documents and materials on behalf of the defendant. Expert costs. 13. Based on JAC records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. JAC does not object to the court continuing this authorization now that the defendant is representing herself. 14. As to other requests for other experts, the defendant will need to file an appropriate motion delineating the following: 1. Identity or type of expert. 2. Amount authorized cap for the expert services. And 3. Rate or rates authorized for the expert services. 15. The defendant has the burden to show the particularized need for each expert witness. The defendant needs to show the services of the expert is necessary for the defense of the case. 16. As enunciated by the Florida Supreme Court, a party seeking due process costs has the burden to establish 1. The particularized need for the due process services, and 2. Prejudice arising from the denial of the due process services. And then they're quoting some court cases here. 17. The determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and the denial of expert assistance would result in a fundamentally unfair trial. Quote those cases there. And costs, ordinary witnesses. 18. The defendant will need to submit a more detailed motion delineating the witnesses that she seeks to summon for trial and the anticipated costs associated with those witnesses. Requirement for JAC due process contract. 19. If any providers desire direct payment, the JAC's procedures require the vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain payment. 20. Because of the unusual circumstances presented in this matter, JAC requests to participate in the hearing set on August 5th, 2024. JAC requests to appear through the communications equipment, which can be reached at toll-free. So it looks like they're probably going to be on Zoom, or on the phone at least. Wherefore, the JAC requests, should the court grant the defendant's motions, also include in its orders the specific due process services authorized, as well as hourly or per unit rates and maximum fees authorized, and that the provider be paid in accordance with rates, terms, and conditions set forth by the Florida statutes and the JAC contract, policies, and procedures. And it's signed by the folks working the JAC. Looks like Christian D. Lake. So, there we go. Those are her motions. And it looks like JAC has approved most of the money she needs. They just need more information about witnesses and experts. And we're going to see more on August 5th what Judge Kranick has to say. And she'll get her access to that laptop next week. And she can begin her duties as pro se Sarah Boone. So let me know what you guys think. I know you all are looking forward to Monday's hearing as much as I am. And with that said, I hope you have a great rest of the day. And most of all, stay safe.